I'm Kayte Lewis from Voice Lawyers, and this is Voice in the Crowd, the podcast for people, not lawyers. It's about demystifying the law, speaking in plain English, and sharing practical insights into how the legal system really works in everyday life. Each episode draws on real stories and experiences, the good, the bad, and the confusing. If you feel overwhelmed or confused by the law, or you're just interested in our stories, this podcast is for you. Voice in the Crowd, where the law meets real people. Welcome back to Voice in the Crowd, the podcast that is for people, not lawyers. Today, my special guest is Louis Katsinas, who is a barrister and the leader at Wentworth Chambers. His areas of focus in law are family law and criminal law, so all the fun stuff. And he's also an accredited mediator in family disputes. Louis was called to the bar in 1997. So I think we might start there, Louis.
Kate, thank you very much for having me on this podcast.
You're welcome.
And thank you very much for reminding me that I'm fast approaching my 30 years at the bar.
Wow.
That's very humbling. Thank you.
So what does it mean then to be called to the bar?
A calling is like something that's within you that draws you to a particular vocation, like a priest or a doctor. And you can distinguish it from a job in the sense that you don't necessarily do it in order to make money, although, of course, that's a significant aspect of being a barrister. But ultimately it represents your ideals, your values, and it's more directed to service of the community.
Right. And so is there any difference between being called to the bar as a barrister and being admitted as a solicitor?
No, because I think a lot of solicitors say they were called as a solicitor and the same way you were called to the bar. So not really.
So I think that's one of the really interesting things that I'd like to talk about today. Well, I hope it's interesting.
Yeah.
People tend to not understand, I will hear them say, well, why do I need a barrister when I suggest I think we need a barrister on this? And we'll often hear that from clients, or, what's that for? Why do I need a barrister?
Yeah. Because of course they're thinking about the associated cost with the, engaging a barrister. But there are many different reasons why you would engage a barrister. But I think the starting point would be to distinguish between the role of a solicitor and a barrister.
Mm-hmm.
And I think then why you need to engage a barrister is self-explanatory. So a solicitor is ordinarily the person who takes instructions off the client at very first instance. They're the ones that sort of build up the case, prepare the case, and then they hand it over to the barrister for the purpose of the barrister undertaking the advocacy in court and arguing the case on behalf of the client. So the solicitor is more the preparer and the barrister is more the advocate.
Okay.
In saying that, sorry to cut across you, in saying that, there are many solicitors who also are also advocates too.
Yeah. Well, I do a bit of advocacy.
I know that.
But then at some point, I'll often go, I think we need a barrister on this one.
And that usually happens when things get a little bit complicated, when you're not sure about something. So you'll go, for example, to a family law barrister who has experience in a particular area in family law. So, for example, in relation to a parenting matter, you may come to me, or in relation to a property matter, you may come to me on a specific issue. Usually there are a number of hearings leading up to a final hearing. They're known as interlocutory applications or interim hearings in the family law context. So that requires specialist knowledge and advocacy skills. So that's, in those circumstances, you tend to go more to a barrister. Yeah.
I think from my point of view, with being a solicitor, I thought that I would do more advocacy than I do. I mean, I do a reasonable amount, but sometimes it's hard to get your head around both sides of it. And I find that then it's better to just let the barrister to take over that side of it, because it is two different ways of looking at a case.
Absolutely.
And two different skill sets.
Absolutely.
Jumping between them is quite difficult.
I can't imagine that it'd be easy. So what makes it easy for a barrister is the solicitor is usually the interface between the barrister and the barrister and the client. So you will obtain all the instructions from the client, but then you'll pass them on, for example, to me, and I'll look at those instructions that you've obtained and I'll tell you whether that fits within the parameters of the case law and whether you need any further evidence. But I can't imagine you doing all of that would be an easy task.
No, it's not.
No.
No. But on some matters, we will do to a certain stage, but then it's easier to just actually make sure you haven't missed anything and let the barrister who's only thinking about the advocacy side
That's
of
right.
things
Yeah.
tell you, because sometimes you can get right down in down in the weeds because you've got the relationship with the client. You can end up sort of not emotionally involved, but you end up in the detail of it, and it's easier to miss something that a barrister will then come in and see.
I think subconsciously, without even realizing it, you could become emotionally involved in a client's matter. And one of the rules of advocacy is that you remain dispassionate when you present your client's case and not become emotionally involved. And that's really, really important to make sure that you're looking at the case objectively. Whereas if you're dealing with a client on a day-to-day basis, of course, that makes it very difficult for you to sort of step back from it when you've been spending so many hours with the client obtaining instructions and then presenting something objectively. I think it's very, very difficult.
Especially in family law.
Especially in family law, where the proceedings by their very nature are emotional.
They are emotional. So you do both family and criminal.
Yes. 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 The two highly
What can you
emotional.
tell me about the difference? There's a lot at stake in both cases, aren't there?
There is a lot of stake. So in relation to family law matters, there's money at stake, so property, there's children at stake, there's other aspects at stake. But in relation to criminal law, there's criminal convictions, of course, and there's someone's liberty, first and foremost, and someone's reputation. I know what I'm going to say now sounds a little bit funny, but in some respects, dealing with a criminal matter, even a heavy-duty criminal matter, for example, such as a sexual assault or a robbery or a intentionally caused grievous bodily harm, is less emotional than dealing with a parenting matter in the family court.
All the criminal lawyers seem to tell me this. They all say to me, "Oh, we couldn't do family law."
Yeah, well, I've picked the two fantastic areas when it comes to clients' emotions. Look, the other thing, if we just go back to the point that you were speaking about before, and I've noticed this with a lot of the solicitors that I work with, but to some extent, because you have a relationship with a client, to some extent, you're acting as a quasi-psychologist for the client too. So they look to you for comfort and guidance, and in order to make the clients feel better, you give them that, and that's where, going back to my previous point, that's where you lose your objectivity and your ability to remain dispassionate. So,
well, I think that is true. I mean, I do not act as a psychologist, Louis. Just let me.
I know that for a fact.
Just let me clear that up. However, you do end up talking to people, and there are often times when I will point clients in the direction of, look, I really think you do need to talk to a psychologist about this, and that would be a good idea. And we do work fairly closely with some psychologists that we can refer off to. Because it's a really, really stressful time for people. And we did a podcast a couple of months ago with a neuroscientist, and we looked at what actually happens to your brain when you're under that level of sustained stress and how difficult it is to make decisions. And we're asking people to make those decisions. Sometimes they have time, and sometimes if we're in the middle of, if we're already at hearing, then they have to make those decisions in a fairly short, high pressured time, and they're hard decisions to make. So having some support and having some preparation, I always think is really important. You can't turn up not having thought about where you want to live or how much money that might cost you, or we've
encountered that problem many times, haven't we? But can I just challenge you on, you just indicated a little bit. How many times throughout the course of your career have you received a comfort call from your client? So a client calling you, not really for any particular advice, but just to make him or her feel comfortable about what's coming up.
Oh, often. All the time. Every time when we're preparing for court, I think mostly. Yeah.
Yeah. So when I say you act like a quasi-psychologist, of course, we don't give psychological advice, but I'm talking about it in the sense of making someone feel comfortable and sort of steadying their mind to be focused.
And letting them know what they can expect and
all that stuff,
what might happen and what the possible outcomes might be and all of those things, which is I guess the solicitor's job. not so much yours.
Because as we've seen, anxiety plays a big part
Yeah.
in court proceedings, and that affects the way people give evidence in court. That affects sometimes the instructions that they give. That affects sometimes the way they behave in court. Like I've seen a client in court who was asked a question, a very pointed question, and he started smiling. And I could tell that the reason the client was smiling after being asked this question is because he felt a sense of anxiety.
Yeah.
Whereas the judge who was hearing the case misinterpreted that for arrogance on my client's part when it was far from that.
Oh,
That's a horrible thing.
yeah. But I mean, is there anything that you can do to prepare a client, you think, for that?
No, look, the only thing you can do to prepare a client is to sit them down before the hearing, explain the whole court process to them, explain the seating arrangements, explain each person's role within the court, the judge, the opposing counsel, the barrister, where the solicitor sit, just so they have a sense of comfort when they walk into the courtroom. Because a lot of people, don't forget, haven't walked into a courtroom for their entire life, so they just walk into a courtroom and they feel intimidated immediately. So just to give them that sense of what to expect, so it doesn't come at them as hard as it does if you don't know what to expect.
I think there's very few places in our modern society that are as formal anymore as going into a courtroom. And so most people don't see it. And I think it's interesting now that, since COVID, where lots and lots of those initial court hearings will now happen online. And I think it's an even bigger shock for people when they do get to, say, final hearing or a defended interim hearing, and they actually have to turn up to court for the first time.
Yeah.
I mean, I have my own personal opinions on that.
I'd like to know what they are, to be honest with you.
You'd like to?
No, I would love to know.
I'm happy to share my personal opinion. People won't agree. Some people won't agree with me, but I think that it's a great loss that first court date is not in person, because my experience was that we would sort so many things out on that first court date because you were there, the client was there. There's a certain sense of, ceremony and formality about it that they've got to turn up to court. And so you're waiting and you've got to wait your turn. You could be there for an hour or 2 hours or more. And so much stuff was able to be sorted out because the negotiation that would happen on that first return date actually meant that that's as far as many matters went. And now, because we've got this, you just call in from home and you log in, and then no one actually gets to turn up to court until quite some way into the proceedings. And it just sort of, and then I'm always confronted. People always go, do I really have to go? And like, yes,
you do.
You actually really have to turn up. And they just don't have the same sense of gravity around it.
Well, just to give credibility to your point that you just made now, Kate, how many hearings are prepared all the way to final hearing? You get to the doorsteps of the court, and when the client is confronted with the courtroom, the judge, barristers in wigs and gowns and all the rest of it, and suddenly they're amenable to try to resolve the matter. Yeah. So I think that just proves your point, doesn't it?
Yes. Well, I think it proves my point too. But, for whatever reason, the system has opted to not do it that way anymore. And I actually think it's running fees up because we're not settling till much later into the matter.
Yeah. Look, I think the way proceedings are run in the family court since COVID, I think it has some pros and I think it has some cons. And I appreciate that you're referring to the first appearance. So my experience with respect to that is you're never going to get a matter to totally settle at the first appearance because both parties have just sort of, maybe one party hasn't even filed their response or their affidavit. But it's unlikely you're going to resolve the matter at the first appearance. But I do think that if the first appearance was by way of personal appearance in court, I think would have less interlocutory applications, less interim hearings, because most of those interim issues will be dealt with at first instance. So, I agree.
Yeah, I think that definitely needs to be revisited, but, who knows?
Look, in fairness to the court too, I think there are so many matters that are going through the system.
Obviously there's the people that are married, but there's a whole lot more people now that don't get married and often are somewhat surprised that they're in the situation where they are considered married. And look, they're very interesting conversations to have with people when you're sort of telling them, well, this is how it is. And they're like, but I didn't ever share a bank account and I didn't ever mean for this to happen. And this was mine.
Yeah.
And that whole de facto creeping up on people is always a very interesting.
Without them appreciating that they're actually involved in a de facto relationship,
Yes. I was actually at an event yesterday where this came up, and there were a number of people sitting around the table who kind of went, "Oh yeah, I think that might be me," and it's like, because they don't realise what it actually then means for them.
I know, and what it means for their property and so forth and so forth. Yeah.
It
has far-reaching ramifications, no doubt. And that's the reason why the court is so busy. I mean,
yes, it is a busy court. All right, so tell me about some of your cases, the best and the worst of it.
Okay.
What comes to mind?
So there is a case where we actually made a precedent, and that involved me acting for a 92-year-old husband who had dementia, and his 52-year-old house cleaner decided that she was going to marry him and exclude the rest of the family from the marriage ceremony.
Can I ask a question?
Sure.
Did he know he was getting married?
That's the.
Oh, okay. Right. Okay. Sorry.
That was the issue with the proceedings.
Oh no.
So we after he was married to the 52-year-old cleaner, she got him to change his will, and of course leave everything to her. And his previous will obviously was of no further effect. And the reason for that is because obviously there was a subsequent will. But if it was found that if he wasn't of sound mind when he prepared the subsequent will, then the effect of marriage revoked any previous wills.
Oh my God. Okay. Yep.
Sorry, am I getting too technical now?
No. I just need to draw a picture.
Yeah. So he ended up passing away, and we had a litigation guardian acting on behalf of the husband, the 92-year-old husband, who happened to be his granddaughter. And we challenged the validity of the marriage on the basis that he didn't understand the nature and effect of the marriage ceremony. And we actually won that case, and we actually made a precedent.
Wow. Okay.
So that was probably one of the better ones that I'm really proud of. And another one was in relation to property. This was one that I did fairly early on in my career. And husband and wife, 3 children, they separate, they don't get a divorce. Children remain living with mum at the house. Husband goes to Western Australia. He accumulates property and money while he's in Western Australia. Mother sits at home and looks after the children. But remember, for 7 years, they're separated.
Yep.
The asset pool was largely comprised of assets and money and property that was generated by the husband through those 9 years of work in the Western Australian mines. And the other side were offering, I was acting on behalf of the wife. The other side offered us 30%. And I'm happy to say that went to hearing, and we ended up succeeding by obtaining an order for 70% of the property pool.
Big difference.
And that was on the basis that whilst you were working in the mines, and the wife wasn't doing nothing, she was looking after 3 children.
Yeah.
And that's something that the husband completely forgot about, and the other side forgot about too. So I was really happy with that outcome. And she was a very deserving recipient, a wonderful, beautiful lady.
It's always nice when you can get a good result for somebody that really appreciates
She did.
the result. You know, that's always.
She got sick during the course of the proceedings, but thankfully she's come through that, and she's really well. So I'm really happy with that.
Awesome.
And I got one up on my opponent, who I'm very good friends with now. So that's good.
Oh, okay. Well, that's always good, because, you know, people forget that we all actually kind of know each other a little bit.
Yes, that's cool. That's cool.
So, yeah. So what about ones that didn't go quite so well?
There is one.
Anything you want to tell us about that?
There is one that sticks out that's given me post-traumatic stress disorder, to be quite frank with you. And that was in my early days when I started doing family law, and I was acting on behalf of the father. It was a parenting matter. The father was diagnosed with a mental health issue, which made him paranoid and a little bit delusional. The unfortunate thing about it is that we got a family report. That family report writer indicated that the father needed to receive treatment. Unfortunately for him, by virtue of the mental illness that he had, it didn't allow him to recognise that he had this mental ability. So every time I gave him advice, he wouldn't take it. I had to put everything in writing. So it just made it really, really onerous and laborious to sort of represent this person, because he didn't take advice and he wanted to go to final hearing. I managed to minimise some of the damage, but ultimately he didn't get the outcome that he wanted, because it was considered that the children weren't safe with him. So that was a pretty bad outcome.
And that's really hard, isn't it, when you're dealing with children's safety? I mean, we've worked on a few cases where this has been an issue, and as I was telling you in the lead up to this, I had another one come in today.
Yes.
But it's quite disturbing, and you do have to act quickly in those cases. So it does kind of take its toll on you a bit, doesn't it?
It does. It certainly takes a toll on you. But to make this matter, what made it even worse is that the client during the course of the proceedings was uttering the profanities under his breath, and the judge, who's now retired, heard them, and then they had court officers come into court and sit next to my client and made sure that he couldn't look at the mother. And
oh goodness,
it was just a
very extreme,
whole experience. So this matter was about 15 years ago.
Wow. Well, there's a lot of mental illness that we have to deal with. And, as we pointed out before, we're not psychologists, but we do get the benefits of working with psychologists and getting expert reports and those sorts of things, and trying to ask the right questions is something that becomes quite familiar.
Yeah.
So what would you advise, hypothetically?
Yeah.
Hypothetically, what would you advise somebody if the other side is, and we hear the term narcissist thrown around, maybe a bit too much, where perhaps they're not, maybe they're just very stubborn people. I'm not sure. But when you've got the other party that just doesn't want to agree to anything.
It depends on what we're talking about, a parenting or property matter.
Oh, well, let's go parenting. Let's go for broke. Let's go to the hard stuff.
Parenting, and we have a narcissist. Look, I think ultimately when it comes to parenting matters, what you should be guided by as a client is the promotion of the children's protection. That should be your first and foremost priority, as far as I'm concerned. So if you're dealing with a narcissist who has the effect of placing the children in danger, or is dangerous to the children just by virtue of his character, and putting the children in difficult situations and so forth, or undermining the relationship between mother and child, for example, or conversely, father and child, if the mother is a narcissist, I think you should be guided by the promotion of the safety of the children. And mind you, that's what the object of the Family Law Act is, isn't it? To promote a meaningful relationship with both parties, both parents rather, if it is safe to do so.
Yeah, and that's a hard one, because it becomes such a subjective thing from both sides. So that can be difficult.
It is a subjective thing from both sides. One party may view someone as being a narcissist, whereas the narcissist may say, no, I'm just sick and tired of being dictated to by him or her. So there's different ways you can look at it. Yeah,
it is hard, that child focus, trying to direct people back to that once it escalates. So, Louis, you're not just a barrister, but you also are engaged as a mediator in family law matters.
Yes.
How does that differ? How do you find that as opposed to being a barrister? They're two very different roles, aren't they?
They are. Absolutely, they are. So as a barrister, of course, you're engaged to promote your client's case to the best of your ability. As a mediator, you're tasked with the responsibility of facilitating a resolution between two warring parties. So, providing a pathway for them to reach agreement. Whereas as a barrister, although you're interested in an agreement, your primary role is to advance their case as much as you possibly can.
So in terms of mediation, what do you prefer?
Look, that's a good question. What I prefer, to be honest, I prefer being on my feet in court.
Do you?
I do. Yeah, I do. I prefer that, much more prefer that. And I'm a little bit of an impatient one too. To be
Oh,
honest.
really?
Yeah, just a little bit.
Really?
Yeah, just a bit. So I don't particularly like sitting around negotiating all day, and
Okay.
that's not my thing. I'd rather be in court arguing the case. But look, sometimes a soft touch is required at a mediation, and if that's required, then I'll do it.
But I mean, you've got how many years did we work out before?
Do we have to
Oh,
repeat
did we
this
do the
game?
maths?
No,
We've got
I know
one
the
more
maths.
year and it's 30 years at the bar. So you've got a lot of experience that you can take to that role.
I do. And look, it depends on the type of mediation that I'm asked to undertake. So if it's a facilitative mediation, then that's a little bit more touchy-feely, where we make all parties feel good about it. I mean, the fact that they're both there means that they both want to resolve it. But personally, I think I'm more suited to an evaluative type mediation, where I go in there and I say to the husband or the wife or the father or the mother, in my view, if the matter went to court, this is what the outcome would be.
So just for people who may not know the difference, there are more than two types of mediation, but there's two sort of common types of mediation. One is the facilitative, which is where you're just helping people talk.
Yes.
And you don't actually input your opinion or your advice into the matter.
No.
And you're just brokering.
And that requires a lot of skill for someone who's used to constantly advocating for a certain...
That would be, yeah.
That's a difficult part.
I do facilitative mediation.
No, you do, you do it also, yeah.
But then there's evaluative mediation, which is when you do give your opinion, and it's kind of a little bit more like a conciliation, which is what the court offers, a conciliation conference.
Yes.
So people are often confused by that too, aren't they? Where they're saying, I've got to go to mediation, I've got to go to conciliation. What's the difference? Why am I doing this one now? And that can be a little bit confusing as well.
It can.
People as they go through the process.
It can. But that's designed on purpose by the court at different stages of the proceedings in order to offboard the parties, hopefully. Because at different stages of the proceedings, you will have different documentation. It is wise to have a mediation, I think, particularly in a parenting matter, after the release of the family report.
Yeah.
Because the family report writer will make recommendations. Hopefully both parties will read those recommendations, take them on board, and hopefully they can work around those recommendations to come to a resolution. So a conciliation conference in property proceedings usually occurs much earlier. But in my view, they should occur, and I think it does occur after valuations are obtained, and after parties have had the opportunity to obtain advice from their solicitor or their barrister in relation to what they're worth in terms of a percentage of the property pool.
Yeah.
So they're designed by the court on purpose in order to get people out of the system, because if there weren't a number of offboarding stations, so to speak, then everything would go to final hearing and the court wouldn't function.
Yeah. So in terms of myths, family law myths, what are the big myths that you think people should know about?
The myths, okay.
Myths.
Look, there's ones that I come across all the time. And in parenting matters in particular, that a parent has an entitlement to live with or spend time with the child, that they have that entitlement without having any regard to the safety of the child. So I've had clients in the past who have a record as long as my arms in terms of violence, clear perpetration of family violence against the other partner, the child, drug issues, and I've had various of those clients. I'm the father or I'm the mother. I have an entitlement to live with my son, whereas they don't appreciate that only if it's safe to do so. So there is no entitlement to live with or spend time with the child, despite the fact that you might be a parent. There are other things that needs to be taken into account.
Is it that it's all the child's the one that has the rights, not the parents?
The court's primary focus is the children in parenting matters, the children's safety and the relationship between, and other factors, of course, which I won't go into. But in my view, the two predominant factors would be the safety of the child and a meaningful relationship with both of the parents.
And that, we can come back to some more myths, but I
Sure.
just want to pick up on that because when you're talking about safety of the child, we've obviously domestic violence is a huge feature in society, but in family court, particularly the matters that are progressing toward a hearing that are going to court.
Yeah.
I mean, I don't have the figures in front of me, but I know that it's the majority of matters that involve some form of family violence
Yes.
when they're going through court.
Mm.
And yet it's quite difficult talking to people about, well, there's family violence. So does that mean that the child has to go with the mother or the father? And that's such a difficult question to answer.
It is a difficult question, and that's a difficult question to answer in colloquial terms because there is specific case law that deals with that. But obviously, the court's main task is to identify the family violence, and then to mitigate against the risk of the child being exposed to that family violence. And it doesn't have to be family violence; it could be to mitigate any risks associated with the child. So that's the court's task.
But then I guess the intersection between like getting an AVO, which is a state-based order, and then the federal-based family court, that's quite a tricky intersection as well sometimes, and something that people find difficult to understand.
It is. There is a specific provision of the Family Law Act which basically says that if a parenting order is made pursuant to that section, that has the effect of overriding the state-based order. So there could be an AVO in place, and the family court can make orders for a father or mother to spend time with the children despite there being an ADVO for the protection of the child or the mother. That happens. I wouldn't say frequently, but it does happen.
Yeah. And that's very distressing for people, but it's important that they understand that the two are separate, that one can actually override the other. I think that's important. Okay, Louis, what other myths have you got about family law?
Well, the myth that I've heard throughout my entire career is what I put in, I'm entitled to stay back out.
That's a fun one.
It is a fun one. That can occur in short-term relationships and marriages. So the court can undertake that exercise to look at, what you put in, you take out. But usually in a medium to long-term relationship, courts look at a number of other factors, including financial contributions, non-financial contributions, future needs, the justice and equity. So to look at the end of it, let's assume we say that you're entitled to 60%, Kate, and your husband is entitled to 40% of a $1 million estate, just to give you an example. The difference between you is $200,000, even though it's 10%. Because you're at 60, he's at 40. So then the court determines, is that just and equitable, taking into account a number of factors. So the court looks at it and assesses it by looking at these factors as opposed to what you put in, you take out.
Yeah. I have to tell you, I was involved in a matter once where it was some time ago, and one of the parties came with a black book. I kid you, a little black book, a series of them actually.
Yeah. And
in that was every expense that they had spent on the children, down to a number of 20-cent icy poles.
Oh, wow.
If you can remember when an icy pole was 20 cents.
Yes, I can't remember it. Yes, I do.
And this person had added them all up, and that was their contributions that they were wanting to get back. And this matter had actually gone through to a private arbitration, so it was a little bit different.
Yeah.
And the short story is that he didn't get back his icy pole money.
Yeah.
But it was interesting because that was the mindset, was that I have kept track of every single thing over the course of the quite long relationship,
and wanted that back.
And wanted it back.
Yeah. See, I mean, if you look at not so much these days, but if you look at a conventional relationships, maybe going back 20 or 30 years, it was always the husband or the male worked and the wife or the partner stayed home and looked after the children. So people seem to think, and there's a misconception around the financial contribution that the husband or the wife makes, because it could be the other way around. Of course, the husband could be a stay-at-home husband or or partner, and the wife or his partner could go out and work and make the money. Non-financial contribution in terms of caring for the children, caring for the house, looking after things and so forth. A lot of people don't place any weight on that and they forget about that.
Oh, look, I haven't had a matter just, as you know, I do a lot of DB CAS work.
Yep.
You know, and I had a matter just last week, 35-year marriage, and only one bank account in one person's name.
Yep.
And it was interesting because this person wanted to know if they could get legal aid. And I had to ask a few questions, and it turns out there was like a $5.5 million property with no mortgage. And this one was going, well, but it's all in his name. It's all his money. I don't have any money. And I said, I'm sorry, but we have to, I don't think you will be successful with that.
Legal aid, yeah.
Because you do actually have money. It's just we have to be able to access it.
That's right.
Yeah. So,
and that brings me to another myth that I've heard, and that is that if a property's not in your name, that you lose it and it doesn't get taken into account for family law purposes. So, I've heard many people say, "Oh, why did you put it in your wife's name, or why did you put it in your husband's name? Why is it your name on the property?" And there's many occasions where I've had to explain to people for family law purposes, it doesn't really matter. It doesn't matter. Whose name is it?
It doesn't matter.
No.
And then that's really shocking for people that are in a de facto relationship who go, but that was my property and this one's my property. And it's like, oh, but we're having all of them together now.
I know.
Yeah. So
many times.
So what about the binding financial agreement? People are really divided on this.
Yeah.
And, practitioners, solicitors, barristers. What are your thoughts on binding financial agreements?
Look, I think binding financial agreements have a place. I think they definitely take the burden away from the court in terms of resolution of property matters, particularly where parties can reach a resolution, which is great. A lot of solicitors don't want to touch it because they're afraid that it could lead to them being sued.
Well, one of the things that I find is that people think they're a cheap option.
Yeah.
But they're not. I mean, they're quite complicated and there's a lot of work in getting them right.
There is. And you've got to make sure you dot your I's and you cross your T's. So you've got to make sure they're valid within the meaning of the Act. But then again, there are certain circumstances where they can be set aside, and that's where the problems arise. So if there's a suppression of evidence, when you provide disclosure to each other, if all the property is not disclosed in the binding financial agreement, if one party is susceptible to undue influence or some sort of fraud has occurred between them. And sometimes a binding financial agreement, assuming everything else goes okay, is great. But there are other times where it creates more problems. Because if a party is dissatisfied and thinks that the binding financial agreement has been procured by some sort of means where it shouldn't be upheld, then the first task that you have to do is file an application in the court, seek to set aside the BFA. If the BFA is set aside, then you've got to deal with the property proceedings. So it can lead to two sets of proceedings.
And then, of course, those people that thought they were safe with their I should also say it's also colloquially referred to as a prenup, because a lot of people refer to them using that American terminology, but in Australia it's a binding financial agreement. Then they're upset. Then they're wanting to sue somebody because they're perceiving that they've been hard done by because it's been overturned, so it mustn't have been done properly. So there's a lot involved in them, and I find from my perspective is that sometimes people think that it's a way they can get out of giving financial disclosure, and so they go, "I know, I just want to do a BFA.
That's want to resolve it.
And it's like, well, I can't help you."
I know. And look, I think what I've seen over the years as a result of solicitors being afraid that someone's going to point the finger at them. You told me that this binding financial agreement resolves all financial matters between my partner and I. And then they work out that it doesn't. A lot of solicitors are giving advice. They still do them, don't get me wrong. They still prepare binding financial agreements, but a lot of solicitors are giving advice about, on certain occasions, how easy it is to set them aside. So I think solicitors are protecting themselves.
Well, look, we would do that too, but certainly there has to be a full disclosure for us to proceed and do that. Yes. All right. Well, What's the best advice you could give to somebody if they were about to start family law proceedings? Or no, let's take a step back. Let's assume they're not going to have to go to proceedings. They're about to separate, thinking of separating. What would be your advice to them with your 30 years of being a barrister in family law?
Sure. What I would advise people to do is to go to a mediation, but an evaluative mediation at the very outset.
Yes, and if you remember what an evaluative mediation is where someone's going to give you their opinion.
From the very outset.
Yes.
The problem is that doesn't always work, because usually when parties separate, there is what is known as situational family violence, where people are angry with each other, they may swear at each other, they may write nasty messages to each other, they may speak in a certain way, they may gaslight the other party. They just generally sometimes become nasty with each other. And a lot of people, when they initially receive advice, think that a form of family violence being perpetrated against them necessarily means that they're entitled to either keep the children away from this other parent, or that they're entitled to more money as a result of being exposed to this family violence. And that doesn't always work out. So when I say evaluative mediation from the very outset, and in relation to property after valuations have been obtained, I think that'll help greatly, but not with all matters, unfortunately.
So how do you know when a matter is going to go all the way? Do you know?
No, I don't, because I've had clients come to me and say, Louis, I want you to go in there and give it to the other side. I want you to argue this, and I want you to argue this. And of course, I'll give them my advice. But many times, like I indicated before, at the doorsteps of the court, they suddenly get cold feet. They start to become worried about getting in the witness box, hearing the sound of their own voice, being under oath, being looked down upon by the judge, being asked curly questions by somebody in a funny wig and a gown. That all becomes a little bit daunting for a lot of people.
I did several years ago the advocacy training as part of the solicitor's advocacy training, which I think is a tiny piece of what you do when you go to the bar. And they got us all to go and sit up in the chair and look down. And I was absolutely stunned at how much you could see from there.
Something that I remember that I haven't forgotten to this day is when I was doing the bar course back in 1997.
Yep.
I remember they made us be a witness, be a barrister, be a judge. And the one that I found the most daunting was being a witness, even though it was a mock trial.
Oh, really? Why did you find being a witness the most difficult?
Because I got the sense that the evidence that I was given as a witness was the most important thing before the court. So whatever came out of my mouth had to be spot on. So I felt that sense of the responsibility of maintaining the truth and giving the evidence to the best of my ability. And I found that more challenging than being or acting as a barrister in the mock trial, or the judge for that matter.
I would have thought being the judge was the hardest. I think that would be very difficult.
You'd be surprised. I think it's easier.
Don't you think it's easier?
It might be harder when you've got to deliver the judgment, because you've got to think about everything. But
okay.
I think during the course of a trial, I think that's not too difficult a job. But I do appreciate you've got to make decisions as you go along. But
you listen to everything.
I think they get the transcript most times, don't they?
Okay, all right.
And they've got an associate.
Okay. It sounds like you think that'd be a pretty cool next move then.
No, I don't think so. No, absolutely not. I don't think I could do it. I just don't think I could. They work really, really hard. I have a lot of respect for the judges and the senior judicial registrars and the registrars of the courts. I mean, I don't think people appreciate how hard they work. Can you imagine every day having to step into a court, listen to evidence, then read the transcript and prepare a judgment? You're running a trial while you're preparing a judgment. So more evidence is coming on. You're preparing judgment after judgment, whilst you're still receiving evidence almost every day, and you still have to churn out these judgments. I do appreciate a lot of judgments are delayed. Delayed their judgments.
We've already got a couple now.
But I can sort of understand why.
Yeah.
How many times have you been inundated with work where someone wants an advice from you and they need it quickly and you just can't get to it?
Yeah, a few times.
Can you imagine sitting in court between 9:30 to 4:00 every day, receiving more evidence, and after receiving that more evidence, you still got to go back and prepare that judgment for the previous matter?
No, it sounds really horrible.
It
Talk
does.
me out of it.
It does.
I definitely don't want to do that. So, look, we know that we say that this is for people, not lawyers.
Yes.
But I think there's probably a few lawyers that do listen to us.
Right.
What would you say to any young lawyers that thought they might want to either become a lawyer or a barrister or a judge?
A lawyer, a barrister, or a judge, so they want to get into the law.
They want to be in law.
I think it's a wonderful vocation. I think it's wonderful.
After 30 years?
Yeah, I do.
Oh, it's actually longer than that, isn't it?
It is.
Because when did you become a solicitor? I didn't put that in there.
Just as well. Don't worry about it. We don't want to.
It's longer, even longer.
It is longer. I think you've got to have a passion for it. I think you do need a sense of serving the community, because as much as you try to remain dispassionate, like I spoke about at the beginning of this podcast, you can't help but be drawn in by the matters that you do and really, really caring. So you've got to be that type of person. You've got to have a great work ethic. There's no doubt about it. You've got to be disciplined, and you've always got to be curious and looking to learn. Because something that I've learned, despite the passage of 30 years at the bar, is I still haven't even touched the sides of what I need to know. I mean, there's so much information out there. There's so much law out there. And the longer I go on, the more I realize how much I don't know.
I said that just this morning.
Yeah.
I was something just came in with the matter and just went, again, this is something totally different.
Yeah.
It doesn't fit any of the usual boxes. And, when am I going to have a day where I'm like, I know exactly what's going to happen today? It's not going to happen.
It doesn't work that way, does it?
No. I'll keep waiting.
But look, I think it's a very rewarding a job, either a lawyer, barrister, judge, whatever you want to do. The greatest thing that I love about it is meeting people, the people that I meet. I've got a lot of colleagues, a lot of friends that I've acquired through the job that I do. There's a lot of friends that I've made whilst working as a barrister at the bar. So it's been fantastic.
Well, it's great to hear your passion.
Yeah.
It's great to hear that you're still passionate after all of this time.
There are days where I'm jaded, but generally I'm passionate. Yeah. Yeah. Generally.
Yeah. All right. So, anything we can expect from you in the coming years? Just keeping going or something special?
No, because I refuse to do it because I just don't want to do it.
Okay.
Yeah.
So it's going to stay Louis Katsinas, barrister at law.
Yes.
And we will have more cases together.
We will.
And more stories to tell.
Many more stories to tell.
All right.
Yeah.
Thank you.
Thank you for having me. I really appreciate it. Thank you. Thank you.
Just before you leave, I have a quick but important note. What we've discussed in this podcast is general information only. It's not legal advice, and it's not a substitute for getting advice tailored to your specific situation. The law, and family law and employment law particularly, are highly fact-specific. Small details can make a big difference. So if something we talked about resonates with you, we encourage you to get proper advice before taking any action. Nothing in this podcast creates a lawyer-client relationship, but we're always happy to point you in the right direction. If there is something you'd like us to discuss, please reach out and let us know, and I hope you tune in next time.